Good morning to those that are attending online.
Good morning, sir.
Morning, Precious.
Good morning,
Humphrey,
sir.
good morning.
Good morning, sir.
Okay, Gary, morning.
Morning, sir. How are you?
Very fine. I can't see Godfrey today. Last week we had Godfrey. Okay, Ray, how are you?
I'm fine, thanks. And how are you?
Very fine, thank you. Okay, so colleagues, today we are going to proceed to Unit 2, and that we'll start from what is known as legal research. Legal research. But before we go into legal research, can someone remind us, what were we looking at last week? Sources of law. Okay, good. So what did we say? Okay, before we look at the sources of law, I remember we first defined what law is. Is there anyone who is remembering what the definition of law is? Okay, so we mentioned that there are so many different definitions of what law is it? And that we came to the conclusion of identifying one by saying, law, these are rules and regulations that guide human behavior. We all remember, right? Mr. Gary, do you remember? Okay. Then we looked at the sources of law. What did we say are the sources of law? The Constitution, yes. What else? Statutes, yes. What else? Sorry? The Bible, yes. We also identified, I remember, the Bible, the source of law. Yes. Another one? Sorry? Treaties, yes. Agreements that are made between or amongst countries, they also act as sources of law, is it? Yes. Apart from that, books of authority, very good. Another one? So there are so many sources of law, okay? So we are not going to waste much of our time on the introduction to law, which I know by now people have come to understand what law is it? So today we are going to look at two topics under Unit 2. We'll look at legal research, and finally we shall look at legal reasoning. Okay, so we start with legal research. Can someone, do we have an idea of what legal research is? Any idea? Any idea? Yes, madam? Very good. A way of finding answers to legal issues. Very good. Or problems, is it? So where there is a problem, we try to find the solutions or answers to that problem, right? Very good. Any other reasoning of what legal research is? Okay. Before we define what legal research is, let's look at the United States of America. So when the US Supreme Court hands down a ruling, people assume the justices base their decision on years of experience and understanding of the law. This is what people think, is it? So now, although the Supreme Court justices know more about federal law than the average lay person, they may not know anything about the case they are ruling on. They may not know anything about the what? The case that they are ruling on. Okay. Now, because of that, we take note of may, they may not. Because of that, this is where legal research comes in. Are we together? Because you may not just pass a ruling without researching. You must research, you must know and defend yourself. Why are you arriving at such a decision? People have to know, is it? So this is where legal research comes in. Are we together? Now, legal research and writing are the heart of law practice. It isn't glamorous or dramatic. Okay? Are we together? So now, if we say judges must research in order for them to arrive at a good research or a good outcome, then what is legal research? Then thereafter, defining what legal research, we will need to know what is involved under legal research. Clear? Because there must be a certain way that must be followed. Are we together? Are we together? So legal research means finding answers in the law to support a legal decision or argument. Legal research means finding answers in the law to support a legal decision or argument. Okay? So it means finding answers in the law to support a legal decision. So what is a legal decision? In this case, what are we looking at if we say a legal decision? Yes, madam? Like a verdict, very good. Very good. Another one? Another, in short, that's judgment, is it? So we are trying to find ways of reasoning. Are we together? A judge should do reason or research before coming up with a judgment. Are we together? Are we together? So whenever an attorney makes a statement in court, they must support it with a law or previously decided the case. Do we all remember last week when we looked at the sources of law? We said one of the sources of law is what? Decided the cases or stare decisis or case law. Do we all remember? Are we together? So if a law already exists or a case was decided in a particular way, other cases must follow that rule. So like I mentioned last week, to say a judge will not come up with a unique judgment on a certain case. They will have to refer to odd what? Cases. Oh, there is a case of murder, like I mentioned last week, for example. There is a case of murder. Okay? So when committing this type of a crime, this person must have used, let's say, a knife. Okay? And that there is a previous case, similar case that happened in the same situation where one murdered the other using a knife. What was the outcome? So the judge will actually rely on the previous what? Judgment. So that he or she is guided properly. Are we together? Am I making myself clear? Okay, so we look at types of legal information. Types of legal information. And by the way, when someone is researching on any legal research, they must know the type of research that they are about to do what? To carry. For example, you take a crime or an offense of, let's say, murder or theft to a lawyer. Okay? They will think of what type of research they are supposed to use. They will not just begin researching and give you, guidance on what you want. They will have to research. How do we go about such type of a criminal case? How do we go about such type of a crime? Okay, what type of questions are we supposed to ask when we go to court? How are we going to defend ourselves? etc. Are we together? So types of legal information. So there is a wide range of legal information available. Okay? There is a wide range of information that is available. So what you need to take note of is that not all of it is relevant to all areas of law. Are we together? The legal issue raised by your case determines the information to research. So if you come up with a certain case, for example, someone must have borrowed money from you and that they don't want to pay you back. So you need legal representation on that. Okay, so the lawyer will have to think of how to handle your case. What type of research are they going to use? They will not use a research that they used, for example, in handling a case of murder on your case of debt. Does that make sense? Or would that make sense? No, is it? So they will have to think of what kind of research to use. Okay? So in general, state laws and regulations support pleadings and legal documents. Okay? So there are three general categories of legal information. There are three general categories of legal information. How many? Three. How many? Three. One, primary or binding. Primary or binding. Primary or binding law. Now, law is codified in constitutions, statutes, regulations, codes, treaties, and the case law. Law is codified in constitutions, statutes, regulations, codes, treaties, and the case law. So that is found under primary or binding law. What does the term primary mean? If we say primary, what does it mean? Primary, what does it mean? Yes, sir? Very good. Like, for example, the start, like you're saying, the start, the beginning, or first information. Oh, we need to hear primary information. It means they need to hear the first what? Information. Are we together? So the second category is known as the secondary source or secondary sources. Secondary source or secondary sources. Now, what we need to know is that secondary sources explain primary law. Secondary sources explain primary law. Okay? So these sources are not legally binding, but help understand the purpose of primary law. Are we together? These sources are not legally binding, but help understand the purpose of primary law. Since we are saying secondary sources explain primary law. Are we together? And so, yes, sir? Someone is saying nobody's allowing him to join. Is Mr. Mware there? Godfrey Mware?
It's been allowed now.
It's been allowed. Thank you so much, VC. Okay, so we continue. So we are saying secondary sources explain primary law. So these sources are not legally binding, but help understand the purpose of primary law. Are we together? So the secondary sources, they help in understanding the purpose of primary law. These include articles, journals, practice guides, legal treatises. Are we together? These sources include legal treatises, practice guides, journals, and the articles. And then these are the ones that helps in understanding what is known as primary law. So I'm sure we all remember what treaties are, is it? Do we all remember what treaties are? Who can remind us? What are treaties? Yes, sir. Agreements that are made between or amongst the countries. So we should always remember that they are not only made between, but amongst the countries. It might be between two countries or amongst countries, 3, 4, 5 countries. They enter into what is known as an agreement. Are we together? So parties that are not part and parcel of that treaty or agreement, they cannot enjoy the outcomes or the benefits to that treaty because they are not legally what? Sorry? They are not part of the agreement. Are we together? So we proceed. Non-legal or supplemental sources. Non-legal or supplemental sources. Now, examples of non-legal or supplemental sources. We have investigative articles, okay? Investigative articles, news reports, blogs, and other material that can support legal advice in some areas of law. So non-legal or supplemental sources such as investigative articles, news reports, blogs, and other material that can support legal advice in some areas of law. Now, colleagues, these or those are the 3 general categories of legal information. Okay? We mentioned 1 of primary or binding law, 2 secondary sources, and 3 non-legal or supplemental sources. So far, are there questions? Mr. Gary, questions?
It's crystal clear, sir.
Thank you so much. We proceed. So when a legal professional takes your case, they begin by researching secondary sources to see what might apply to the facts of your case. Are we together? When a legal professional takes your case, they begin by researching secondary sources to see what might apply to the facts of your case. So we all remember the primary sources, huh? What are the primary sources again? Sorry? Statutes? Sorry? Treaties? Case law? Okay? Okay. So, in this case, we are looking at the articles, the journals, the practice guides, legal treaties, etc. Yeah? So this is what we are looking at. So when a legal professional takes your case, they begin by researching secondary sources to see what might apply to the facts of your case. For instance, or for example, if you have a real estate dispute over property lines, the attorney might review how property disputes have been handled in your jurisdiction. Okay? Are we together? So different countries may have other agencies that oversee property boundaries. Okay? So when the attorney knows what law to research, the next step is to review primary law to find the codes and case law that will support your claims. Are we together? When the attorney knows what laws to research, the next step is to review primary law to find the codes and case law that will support your claims. So what we are saying is the attorney will first start with the secondary, primary, is it? Then thereafter, they'll go back to what is known as the primary law. Are we together? In that order. Clear? In some cases, such as property law, attorneys must do legal research on other statutes. Okay? In some cases, such as property law, attorneys must do legal research on other statutes. Property cases can depend on the laws at the time of original deed. Colleagues, are we together? The online class, you seem to be quiet. Are we okay? Online
Yes,
class,
sir.
are we? Precious, okay. Mr. Gary,
Yes, sir, I'm following.
it's unfortunate I can't see Mr. Godfrey today. Okay, so we proceed. Precedent. We look at precedent. Do we all remember what precedent is? Do we all remember what precedent is? Who can remind us of what precedent is? What is a precedent? Or a scenario of what a precedent is? Okay, so if you can't remember what this is, I'll take you back to the three things that I mentioned in my preamble last week. I said, according to my understanding, a lawyer should do three things. How many things? Three things. One, a lawyer should be studying. Study as a lawyer, always study. Then thereafter, what are you supposed to do? You revise, okay? So you revise based on what you were studying. It could be the previous night or morning, or afternoon or evening. You revise, okay? Then thereafter, what are you supposed to do? You read. So you can read even at a noisy place. For example, you are with colleagues and that maybe somehow you're not taking part in the stories that they are telling. You don't have that interest. You get your book or your laptop, you begin reading. You can read even at a noisy place. So practice those three things. You will not be forgetting. Are we together? You're not supposed to be forgetting as lawyers. At least if you forget, you must know where to find the law. So they say a good lawyer is one who knows where to find the law. Clear? A good lawyer is one who knows where to find the law. Okay? So, we mentioned last week what a precedent is. It came in form of a scenario. For example, I'll give another practical example. Today, if we say a sitting president should be in office for 8 years, we change the law to 8 years. What are we setting? We are setting a precedent, good or bad. Are we together? The next time we have a change of government, for example, they will follow the same. They will say, but there was a precedent that was already set, that a president should be in office for how many years? 8 years. So you have set what is known as a precedent, good or bad. Are we able to tell what a precedent is? We are? Thank you. So the US legal system is based on precedents. That means that when cases, facts, and legal issues are similar to a previously decided case, the judge should follow the ruling in the previous case. So, like I've said, there is a case that previously happened and that the ruling was this A to B or A to Z. Then there is a current case that is similar to the previous case. The judge will not waste time. They will simply go back to the old what? Case that was similar because precedent has already been set to help them in arriving at the new judgment or decide on the new what? Case. Are we together? Because there is already a precedent that has been set. Clear? So there is what are known as binding precedents. There are what are known as binding precedents. In short, I'm looking at the two types of precedents. One, there is what is known as binding precedent. Now, what is a binding precedent? Binding precedent meaning the judge must follow the previous ruling. Binding precedent meaning the judge must follow the previous ruling. Decisions handed down by the US Supreme Court are usually binding precedents. Decisions handed down by the US Supreme Court are usually binding precedents. So binding precedents meaning the judge must follow the previous ruling, like we have already explained, is it? The judge must follow the previous ruling. So that is what is known as binding precedent. It's binding. Are we together? The second one is what is known as persuasive precedent. Persuasive precedent. Meaning the judge may follow the ruling but is not required to. You understand? Persuasive precedent meaning the judge may follow the ruling but is not required to. It's not mandatory. The judge may follow the ruling of the previous what? Case. But it's not mandatory that he should come up with the same judgment that was used in the previous case. It's just there, like the term itself, persuasive. Okay? Like you're trying to persuade someone to do something. Are we together? So persuasive precedent meaning the judge may follow the ruling but is not required to. Most case law is persuasive precedent. Most case law is persuasive precedent. Okay? So if an attorney can present sufficient grounds of distinguishing a case from the precedent, the judge may rule in their favor. Okay? If an attorney can present sufficient grounds for distinguish a case from the precedent, the judge may rule in their favor. So what is important is for an attorney to have sufficient grounds for distinguishing a case from the precedent. To distinguish, what is to distinguish? To differentiate, is it? So if that can be done, then the judge may rule in their favor. Is it making sense? Okay. So it's very unusual to proceed after looking at precedent without looking at stare decisis. Are we together? It's very unusual. So stare decisis or to stand by the thing decided. Stare decisis, you remember this is a doctrine, eh? Do we all remember the doctrine of stare decisis? So stare decisis or to stand by the thing decided is a doctrine whereby judges must adhere to previous decisions. Judges must adhere to previous decisions. So vertical stare decisis refers to decisions handed down from higher courts, like the term itself, vertical. So meaning there are two types of stare decisis that you need to take note of. There is one, the vertical type of stare decisis. Vertical type of stare decisis. What does it mean when we say stare? Vertical. Vertical. What does it mean? Mr. Gary or anyone attending the online? Sorry for those that are attending the online class. You might feel offended that I'm only mentioning Precious and Gary. You see, my PC here is only showing me two names, but I know there are a lot of names that are people that are attending, but I can only see Gary and Precious. So the rest, don't feel offended. So those that are attending online, what do you understand by the term vertical? So in our yes, Mr. Ray, I can see Ray.
Yeah, thank you. I
Yes.
think vertical stare decisis means that being bound by a decision made by a superior court.
Very good. Thank you so much, Mr. Ray. Colleagues, did we hear that? Did we get it? So in short, what Mr. Ray is saying, a vertical stare decisis refers to decisions handed down from higher courts, superior courts, higher courts, right? Okay. So the other type of stare decisis is what is known as horizontal stare decisis. Horizontal stare decisis. So who can help us define what horizontal stare decisis is? I've been talking much with the physical class, so I want the online class also to be participating. Could be Mr. Ray, Mr. Gary, or Precious, or the others that I've not mentioned. Who can help us define? Yes, Precious?
Okay, I think horizontal stare decisis, it refers to a court that is adhering to its own precedent.
Okay. Can you repeat that, Precious?
Okay, it's a court that is adhering to its own precedent.
A court that is adhering to its
To its
own
own precedent.
precedent. Okay, very good. Apart from that, anyone with a different definition? So Precious definition is okay. I agree with Precious. Another one? Okay, we proceed.
Sir, if I may.
Yes, Bruce.
Yes.
Mr. Bruce, how are you?
I'm all right, sir. How are you?
Mr. Bruce, are you there? Yes, Mr. Bruce.
Yes, sir. Are you able to get me?
Yes, I can now.
Okay. If I may try as well. Not
Yes.
necessarily contradicting what my colleague.
Okay, although your line is breaking, but continue. We'll try and make sense from what Mr. Bruce will put across.
Said, but I think it's also
so sorry, Mr. Bruce, I'm not cutting you short. I
think it's are you able to get me?
Okay. Now I can. Courts at the same level, you're saying?
Courts at the same level follow decisions of other courts at the same level within the same jurisdiction.
Okay. So which is similar to the definition of what our colleague had earlier put on, Precious. Very good, Mr. Bruce. Yes. Very good. So in connection with the two definition, which is the same with what I'm about to read to you, horizontal stare decisis refers to decisions made by courts within the same jurisdiction. So what the two colleagues have defined and what I've read to you are the same. No difference at all, is it? So what do you understand by the term jurisdiction? If we say jurisdiction, what does it mean? Jurisdiction, yes, sir? It's more like a boundary. Okay, very good. Very good. Another one? Good, sir. Another one? So if we say Nantinga is your name? Sorry? Nintanga. If we say Nintanga is a magistrate, do you think Nintanga has the powers to sit in the Supreme Court? If we say Nintanga is a magistrate right here at Magistrate Courts, do you think Nintanga has the powers to sit in the Supreme Court? No. Meaning, her jurisdiction ends from the magistrate, is it? The powers that she has cannot go beyond, is it? Are we together? Colleagues online, are we together?
Yes, sir.
Okay. So we proceed. So in general, Supreme Court and Appellate Court decisions carry more weight than Circuit Court decisions. Okay? So that is a conclusion on stare decisis after identifying the two types of stare decisis, which are vertical stare decisis and horizontal type of stare decisis. So we are saying, in general, Supreme Court and Appellate Court decisions carry more weight than Circuit Court decisions. So, thereafter looking at that, colleagues, we proceed into looking at what is known as how to do legal research. How to do legal research. Okay? How do we do legal research? I'm sure there must be a guide on how to do legal research. How do we do legal research? Now, what you must understand is that you don't need law school to do legal research. Okay? You don't need a law school to do a legal research. Are we together? Nowadays, things have been simplified. Okay? During our time, the time we were at school, during our time, in the early 1960s, you people are very lucky today that you have these platforms such as the internet, you have these gadgets such as the computers. With us, it used to be manual during our time in the 1960s. So consider yourselves to be lucky, one of the lucky people, is it? So now we are saying you don't need law school to do legal research. If you have a legal problem and want to know more about it, what can you do in the absence of a lawyer, for example? You can go online, use your Google and research or search for what you want to have at the end of the day, is it? Which is why I'm saying you are very lucky people nowadays that you have these platforms or gadgets such as computers, phones, internet, etc. With us, it used to be manual. You need to find a book, go through the table of content, etc. So you have a problem, you go online on your phone or a laptop, etc. Search, a solution will come and you understand from there in the absence of a lawyer. Are we together? So, if you have a legal problem and want to know more about it, online legal research tools have made research easier for the lay person. Are we together? So we have useful services like Google, LexisNexis, the Westlaw, etc. Okay, so those actually can act as sources of your research. Not any type of research, but sources of your legal research. Colleagues online, are we together?
Yes, sir.
Okay. Okay. So now, before you jump into legal research,
So sorry there.
yes, sir.
My apologies, say for disturbing you.
No, 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 no.
I,
You're not
I,
supposed to apologize, sir.
I just
Yes, sir.
wanted to ask you something. Say,
Yes, sir.
do you have a recommended website for case laws or for legal research, especially for Zambian cases?
For Zambian cases. Okay.
Yes. Do you have a specific site which is probably authenticated by yourself?
Uh-huh.
Say maybe if you can go to that site, particular site, like in Zimbabwe,
Uh-huh.
legal practitioners, they've got a particular website which
Yes, yes, yes.
they extract
Yes, yes,
case laws which are supported by the local courts. So I
yes, yes.
wanted to ask you, do you have a specific website maybe to mention just for sake of research?
Okay. So we have quite a number of those. I'm going to share with you at an appropriate time. Eh?
Okay, thank you,
Is
sir.
that clear, sir?
Yeah, it's okay. Thank you.
Thank you so much. Can we proceed? Okay. So before you jump into legal research, you should ask for some help. Before you jump into legal research, you need to ask for some help. Are we together? You need to determine the area of law you are researching. You need to determine the area of law you are researching. So what you need to bear in mind is some types of law need special research skills. Okay? Some types of law need special research skills. Are we together? So for example, you have what is known as tax law, intellectual property law, you know, you have criminal law, you have family law, etc. So you need to sit down and analyze what type of law am I researching on. Because you cannot go into family law when what you want to research on is based on criminal matters. Someone steals from you, okay? So that's a criminal case, is it? And then you go and research on family law. Does that make sense? Or would that make sense? It wouldn't. It's a civil case, you go and research on a criminal case. It wouldn't add value or make sense at all. So you need to know what type of law you are researching on. So now let's quickly look at steps of legal research. Steps of legal research. Steps of legal research. Steps of legal research. So first step, you need to identify your legal problem. You need to identify your legal problem. That's the first step. Is it? What do you need to research? You know, what do you need to research? Are you trying to research a title deed? Or do you need to modify a child support order? So in short, you need to identify your legal problem. That's the first step you need to take. Okay? Secondly, find a legal research tool that will work for you. Find a legal research tool that will work for you. Okay? So when we say tool, what do we mean? A tool, as in TOOL. What do we mean? Find a legal research tool that will work for you. What do we mean?
Maybe a source of law.
A source of law? Okay, good try. Madam Precious? Good try. Any other one? Any other one?
Yeah.
What do you mean when you say, yes, Mr. Ray?
I think it's the methodology.
The methodology that one will use. Okay, good. Good try. Remember in my preamble, when I looked at the three different groups of people that existed way before you and I were born. Do we remember that story? We do? Where, in short, we say every human being is a potential philosopher. What I think is right might be wrong in Mr. Ray's eyes. And what Mr. Ray thinks is okay or right or opinion, it might be wrong in Precious's eyes. So in short, there are no wrong answers. What we are trying to do is to connect to the correct idea or something that shall help us at the end of the day. Are we okay, colleagues? So find a legal research. Yes, find a legal research tool that will work for you. So what type of tools? Tools are things that will help you. In short, tools that are things or gadgets or materials that will help you in your research, or things that will help you to carry out your research, such as Google itself. Are we together? Or books or materials, anything that will help you in carrying out your research, it is known as a tool, such as Google, or it might be an online legal research service, such as Find Law. Are we together? That is a tool. Okay? So we are saying steps of legal research. One, we have identify your legal problem. Two, find a legal research tool. And then three, enter your legal issue. Three, enter your legal issue. So all legal research tools have a search function that lets you enter your query in plain language. For example, if you are using Google, are we together? You should be able to research. It could be in any language that you understand. It could be Chinese, it could be Bemba, it could be English, etc. Is it? So enter your legal issue. You enter your legal issue onto that tool that you are using. Are we together? All legal research tools have a search function that lets you enter your query in plain language. It does not restrict you of the language that you want. Does it? It doesn't, huh? So 4, which might be the last one on this one. So once you have done your secondary research, you can begin your primary research. Remember, in our preamble, we stated to say a lawyer will firstly start with the secondary type of research, or what? Or remember, there is primary, secondary, and the third one? Sorry? Supplemental. Very good. So the first one that the lawyer will use is the secondary. Then go back to the primary. That's what we stated in our discussion, is it? So we are saying once you have done your secondary research, you begin, or you can begin your primary research. Now you may need legal assistance from an attorney. So what you have done, it is just something that you can do on your own. But then at some point, you need help. Is it? You need what? Help. So you may need assistance from there on how to be guided. So assistance from where? From any legal-minded person. You will not restrict yourself from an attorney or to an attorney. No. It could be any person who understands the law or the legal research paper very well. It could be your lecturers. It could be the lawyers or anyone that understands the law in short, properly or well. Are we together? So now, we look at how your attorney uses legal research. How your attorney uses legal research. How your attorney uses legal research. So now, if you go to a law office for help, the attorney or paralegal will do more research on your case. If you take your case, the first thing they will do is to do more research on your case. Before they do anything, they will have to carry out a research on your case. Are we together? They will be looking for precedent and case law described above. Above, remember what we looked at? So after identifying the problem and everything, taking a research on your case, now they will look or they will be looking for precedent and case law. Okay, so this case that we have currently, do we have precedent over it? Do we have any decided case or cases over it? What they are carrying out is what is known as a what? A research. Are we together? Then the attorney, in this case, more likely the paralegal, will write the first legal documents in your case. They will write the first legal documents in your case. They'll begin analyzing. What are we supposed to put up? How are we supposed to argue this case? Is it on the positive side or the negative side? They will advise you, which is why they are there. Are we together? Okay. So for instance, if you claim your neighbor's fence is encroaching on your property, your complaint will include a copy of your deed with the original survey lines. Is it? If you are claiming to say someone has trespassed or they have built on your land, what are you supposed to do? You have to present the what? The legal documents in support of your argument. Oh, this is what I mean. So if I say this person has encroached, indeed they have encroached because my land is, for example, is 30 by 30. So now what is remaining is 30 by 25. The 5 meters has been encroached by these people. You show them. Are we together? They say, he who alleges must do what? Prove it. If you are saying she stole money from me, you must prove it to say indeed she stole money from you. That's what the law says. Is it? You will not just claim to say she stole money from me and you expect the outcome to be in your favor when you ended just there. No, that's not the way it works. You must prove it. Show evidence that indeed she stole money from you. Are we together? Are we clear? Colleagues online, are we together?
Yes, sir,
Yes,
we
sir.
are following.
Very good. So in that example, it will include the original plat map of the development on the title deed. Remember the example that we're talking about. If you are alleging that someone has encroached on your land, okay? So you need to provide a title deed that shows original survey lines. It will include the original plat map of the development. It will also include a citation to case law in your state, okay, about adverse possession claims for properties transferred before a certain date. After that date, the state changed the laws for adverse possession. This means your neighbor cannot claim adverse possession because the fence hasn't been there long enough. So that is how precedent and legal research work. So in short, this example is telling us about providing evidence to whatever that you are claiming for. Are we together? For example, you are in class, attending class today, and then there is an instruction somewhere that all those that have not paid school fees or tuition fee must not attend your lecture. Are we together? So me, being a lecturer who is not an accountant, I'm not aware who has paid and who has not paid, is it? So it will be up to you to provide me with evidence to say, no, I have paid, here is a receipt. Or vice versa, if I claim to say, can you go outside because you have not paid? Can you go outside because you have not paid? I must provide the evidence of my claims. Or you have not paid. My record shows that you have not paid. So these are the receipts that I have. Amongst the receipts that I have, your receipt is not reflecting it. Means you have not paid. So can you please excuse us? Just an example. Please don't feel offended. It's just an example. Okay. So, legal researchers carry out this research in almost every area of law. Corporate lawyers conduct legal research to determine if a proposed policy would expose the company to liability. Are we together? Are we together? Are there questions so far? We are together. Mr. Bruce, we are together.
Yes, we are together.
Thank you so much. Thank you so much. So far, are there questions? Are there questions so far? Or contributions? Now, Godfrey, Mr. Godfrey, welcome. How are you?
I'm fine. Good morning, sir. So I kindly just differentiate between primary and secondary legal research, because from how I generally understand research, it's like we are using resource like books and research. And to me, it's all falls within secondary research.
I can't clearly understand what you are trying to say or talk about because of network, but from what I can connect, are you trying to ask the class or myself to differentiate between primary and secondary source?
Yes, sir.
Okay. So, in our preamble on this one, I asked what people understand by the term primary. So we said primary may mean first. Primary may mean first. If we say there was primary information, it means there was first information. Are we together? So now this first information might come from sources such as, can we give examples? Can I have people participate? These are things that we are looking at for the third time now from last week. Primary sources. Mr. Godfrey wants to understand the difference between primary source of information and the secondary source of information. Is it Mr. Godfrey?
Yes, sir.
Yes. So before I look at that, can anyone of us, either from the physical class or the online class, differentiate between the primary source of information from the secondary source of information? Anyone to differentiate for us?
Right. A primary source are
Yes,
binding
Mr. Ray.
law codified in statutes such as
Okay.
constitution, regulations, treaties,
Mhm.
and the case
Mhm.
laws. Then
Mhm.
secondary sources explain
Mhm.
the primary sources. They are not
Mhm.
legally binding,
Okay. Thank you
but
so much.
they help to
Mhm.
understand the purpose of the primary law, such as
Okay.
journals, legal
Mhm.
treaties, legal guides, or legal
Mhm.
statutes.
Mhm. Mhm. Okay. So thank you so much. Thank you so much for that. Any other one? That's a very, very good one, Mr. Ray. Any other one? So I'm going to, yes, madam. First aid information, yes, Constitutions, statutes, treaties, etc. Very good. Very good. Very good. Okay. So all those definitions are correct. So I'm going to redefine or distinguish between primary source of information from secondary source of information to make our colleague understand. Okay. So primary sources establish the law. Like I said, primary comes from the word first. Okay. So primary sources establish the law. They include cases, statutes, regulations, treaties, and constitutions. So relevant primary sources have the greatest influence on the outcome of any legal issue. Are we together? Relevant primary sources have the greatest influence on the outcome of any legal issue. So secondary sources explain the law, but do not themselves establish binding law. Remember what we mentioned, eh? So secondary sources explain the law, but do not themselves establish binding laws. Sir, have we made ourselves clear on that one?
Yes, thank you, sir. Thank you very much.
Thank you, Mr. Godfrey. I kept on mentioning your name. Huh? It's a good thing you've come online. Okay. So, colleagues, like I mentioned, I intended to go up to the second topic, which is legal reasoning. Unfortunately, I will reschedule this topic for some days. Legal reasoning. Okay. So my timing was not okay. I thought legal research was going to take about 30 to 40 minutes. So I've just realized that it has consumed about an hour or so, an hour plus. So our next topic shall be legal reasoning. Our next topic shall be legal reasoning. Now, under legal reasoning, I want you, all of you, the physical and the online class, to go and look at a case of Donog versus Stevenson, 1932 case. Under legal reasoning, I want you to go and look at a case of Donog versus Stevenson, 1932. So, in that case, I want you to come up with the brief facts and the final ruling. So, in short, what I'm trying to ask you to do is to go and read on the case of Donog versus Stevenson. Go and research, go and do a legal research on Donog versus Stevenson, 1932. The physical class, each one of you will have to tell me something about the case of Donog versus Stevenson, 1932. Look at the brief facts, the ruling, and everything. So, in that case, I request you to think deeply. What happened in that case? What is your legal reasoning in that case? To some extent, if you can, I want you to contradict giving reasons, the outcome, the actual outcome of that case. If the case was in favor of Mrs. Donald or in favor of Stevenson, whatever way, I want you to contradict it using your own reasoning. You understand, eh? Yes. If the case was in favor of Mrs. Donald, I want you to contradict that. If the case was in favor of Stevenson, I would want you to contradict that. So colleagues, online, have you gotten that one?
Yes, sir.
Yes, eh? Thank you. Thank you so much for attending. So our next class will be, what will be the date on Thursday? It's a holiday. Okay, so I've been guided that Thursday it's a holiday here in Zambia. For those that are attending online from different countries, I am sure it won't be a holiday. So then, because it's a holiday here in Zambia, we shall move it either to Wednesday or Friday. Can we agree? Which day? Wednesday, just after tomorrow. Tomorrow is Tuesday, is it? Okay, Wednesday, what time? Wednesday in the morning. So in the morning, we mean 9 hours. You have criminal law. From what time to what time? 8 to 10. 8 to 10, you have criminal law. Okay, so we can have legal process on Wednesday from 10 hours. Is it okay? No, 12, it's not possible for me. Any time after 12 hours on Wednesday, it will not be possible for me. Okay, let's do this. We'll communicate using our usual way of communication. Okay, so for now, we leave it 10 on Wednesday. For now, if there will be any changes, then we shall communicate, is it? Colleagues online, is that okay?
That's in order, sir.
That's what?
I said it's in order.
It's in order.
Yes.
Thank you so much. It should always be in order. All right, thank you so much. So then, our next meeting will be on Wednesday, 10 hours. Want to what? To mark the register. How do you mark it? Or the online student, I'm told you wait a bit, she wants to mark the register. So it says there are 7 people that are present, 7 plus, huh? So I want to see the names. Want to see the names. I don't know how you do it now. Okay. I don't know how you look at that.